Sprung, and welcome to this edition of Midland Minute. For those of you who follow us on Facebook, LinkedIn, or even on our website, you may have noticed I posted a new article this week on the power of a power of attorney. And I thought it was appropriate for us to go live and give you some more information about that because it has created a bit of a stir and a lot of good questions coming out of that article. So I thought it would be best for me to share a story to maybe show you the power of a power of attorney. So let me get started. So let's say you're in a situation where there's an accident in the family, God forbid. And one of you, husband and wife, let's say one of you is injured in such a way that you cannot handle your day-to-day affairs. Let's say you happen to be the solo person on the mortgage or solo person on a bank account, and your spouse needs to take care of that payment or that process, finding out if a payment is due, or simply making a withdrawal from the bank account. Well, without a power of attorney, that is not going to happen. You're not going to be able to get that information. But by having a power of attorney, what that allows the power of attorney to do is step in the shoes of that individual and take over the day-to-day affairs of their financial life and many other aspects of their life. You know, basically, if you think about it, when you set up that power of attorney, what it's really doing is you're handing over the keys to somebody else to drive your financial life. And that is where the power of attorney comes into play. There is no other document like it. Now, just keep in mind, there are a couple of different types of powers of attorney, which we talk about in the blog article, so feel free to visit midlandfinancial.com and read the recent article. And also keep in mind that the power of attorney ceases upon death. One of the questions that we get quite often is, hey, you know, my loved one has passed and I need to step into their shoes. Can I use my power of attorney? The answer to there is no. Once somebody is deceased, once somebody is deceased, it now turns to the executor of their estate, which has to be appointed by the court in order to allow them to step in the shoes. So the key here is, I don't care how old you are. Once you're 18 years of age or older, you really should have a power of attorney put in place. Give you another example. Child goes off to college, decides to study a year abroad in Europe, and they have bank accounts left behind here, and something happens while they're abroad and they need to handle something with that bank and they cannot communicate from where they are. Who's going to take care of that? Well, if you're mom or dad and you're not on the account, they're not going to speak with you. Again, another instance where that power of attorney is key and vital. And your child may only be 18, but it's important for them to have that power of attorney. So what's the moral of the story here? Think about it. If you don't have a power of attorney, you should be contacting an attorney today. And let me clarify that by saying you should be contacting an estate planning attorney. Don't go to your real estate lawyer, your general practitioner. Go to an estate planning attorney to draw up that document and maybe other documents that you need that we'll cover in future articles and future Midland Minutes. So I'll leave you with that for now. If you have questions, feel free to comment below. We'll be happy to answer them. Or you could always call the office at 844-4-MIDLAND, MITLIN, and we'd be more than happy to assist you in any way we can.